The European Court of Human Rights in 2011 interpreted the Article 9 right to freedom to manifest belief to include conscientious objection and overturned the conviction of an Armenian Jehovah's Witness for his refusal to perform military service at a time when there was no other option available to him. And as respect for conscience applies to those who refuse to participate in the taking of life in war, so it has been applied to those who refuse to be involved in what they see as the taking of life through healthcare practice. My Lords, in 1967, when the UK legislated to decriminalise abortion in certain circumstances, provision was made for conscientious objection because it was understood that what was being made legal was regarded by some as the taking of life. Were it not so, there would have been no need for protection of conscience. And in 1990, when the Human Fertilisation Embryology Act was passed, there was again limited provision for conscientious objection. And in every instance in which your Lordships' House have discussed assisted dying, there has been provision for conscientious objection. And of course, where conscientious objection is permitted, it's not absolute. Medical practitioners must assist to save life, to prevent grave or permanent injury. And it's a complex field, my Lords. Some have rights, statutory rights. Some, like GPs, have contractual rights not to engage. But it's a contractual right and not a statutory right, and some have no rights at all. And why does it matter anyway, my Lords? Professor Dan Brock, a leading bioethicist at Harvard, describes conscience as the basis of an individual's moral integrity, saying it defines who, at least morally speaking, the person is. Maintaining moral integrity, he asserts, requires that a person does not violate their moral commitments. And that is why, my Lords, we allow conscientious objection in healthcare, so that people can maintain their moral integrity, without which major health and other problems will almost inevitably emerge. Through conscience, each of us decides whether an action is right or not. Conscience is fundamental, as Sarah Fauvogue and Dr. Mary Neal state, is fundamental to moral agency, and it's a proper feature of all areas of human endeavour, including professional practice. And the provision of medical services, my Lords, of course, is never value-free. Healthcare practitioners make moral judgments all day, every day, very often very difficult judgments. And in 2010, when the Equality Act was passed, freedom of religion or belief was accorded protected characteristic status, like sex, age and disability. And, my Lords, protection from discrimination, from exclusion on grounds of religion or belief is provided for in Section 13 of that Act, which defines religion and belief as any religious or philosophical belief. And it says that a reference to belief includes a lack of belief. Conscience, my Lord, is not the preserve of the religious. Those who think that it's wrong to end human life do so for many reasons: scientific, philosophical, religious, and other beliefs. The right to conscientious objection exists as a protection for medical professions from the moral injury of being involved in actions which they believe destroy life. It exists, too, for the protection of patients who can believe that the professional looking after them can act in accord with their conscience. Conscientious objection, my Lords, operates at the margin of medical treatment, where the duty to do no harm moves to accommodate positive action to end life. And it's not just domestic law which recognises the right of conscientious objection. The Council of Europe's Parliamentary Assembly adopted Resolution 1763, affirming the right of conscientious objection for medical professions. The resolution states, "No person, hospital or institution shall be coerced, held liable or discriminated against in any manner because of a refusal to perform, accommodate, assist or submit to an abortion." It's non-binding, but it reaffirms the normative understanding of freedom of conscience. Society has changed, and the law has been interpreted differently in the United Kingdom. In 2014, the case of Greater Glasgow Health Board against Duggan and another was heard by the Supreme Court. In this case, 2 senior midwives conscientiously objected to having delegate tasks to supervise or to support those who were directly involved in abortion. They had been able to assert this right of conscientious objection for their whole nursing careers, which started very shortly after the Act was passed, until an amalgamation of hospitals led to their being required to do this work. Ultimately, they couldn't, in conscience, have any role in the provision of abortion. They, skilled, compassionate, experienced midwives, were unable to continue to serve as midwives, doing what they had done all their professional lives, helping women through the sometimes difficult process of carrying and bearing a child. I know that that is difficult. Anybody who has carried a child knows the sensitivities attached to it, and those good women were lost to the profession because the Supreme Court decided that indirect roles taken by nurses and midwives were excluded from protection under Section 4 of the Abortion Act. My Lords, it simply can't be consistent with conscience to say, I cannot do this, but I will order you to do it. If one delegates, supervises, or supports an activity, then one is not unreasonable in concluding that one shares moral responsibility for what happens. And there's a lot of evidence that medical professionals are suffering serious disadvantage and discrimination for their beliefs. A 2016 ad hoc cross-party inquiry into freedom of conscience and abortion provision specifically received many accounts by medical professions who have experienced discrimination during their work life due to their beliefs. I have heard so many stories of young doctors and nurses contemplating their future who have decided that although they would dearly love to be involved in obstetrics and gynecology, even though they're energized and feel vocationally called to the medicine of helping women through conception and childbirth, nevertheless they cannot do it because they could not in conscience kill an unborn child. And that's why I have introduced this bill. Its provisions seek to affirm as a matter of statute that no one shall be under any duty to participate in activities they believe involve the taking of human life, either in the withdrawal of life-sustaining treatment or in any activity authorised by the 1967 or 1990 Acts. Such a reform would re-establish legal protection for medical conscientious objectors and reaffirm the Article 9 rights of healthcare workers. It would give reality to the protections afforded in the Act. There's a serious shortage of healthcare professionals, my Lord. We're having to bring doctors and nurses from abroad. We spent £100 million bringing 3,000 GPs from other countries this year. We're short of 3,500 midwives, and we spent, according to the Royal College of Midwives, nearly £100 million for agency nurses. There's a problem. And many young doctors, midwives, and other healthcare professionals are leaving the UK. Many reasons for this. One of them is that those who labour at the coalface cannot engage with certain activities. We invest in their training. We need their skills. It is time to accommodate them. I emphasise again that this bill is not about reducing access to the termination of pregnancy or the withdrawal of life-sustaining treatment. It would simply mean that healthcare workers of many different kinds, in registering their objections to the procedures defined under the bill upon appointment to a role, must be reasonably accommodated by those managing them so that they may work without involvement in those areas. My Lord, 68% of abortions, 126,000, are NHS funded, but are provided by private companies. 2% are privately funded. 30% take place in NHS hospitals, alongside all the other obstetric and gynecological procedures. 92% of abortions in 2016, 170,000, were carried out at under 13 weeks gestation, increasingly medical abortions involving the use of medication. And that gives rise to the necessity to protect rights of conscience of both GPs and pharmacists not to provide these services. That is what the bill seeks to do. The NHS could accommodate the number of conscientious objectors rather than forcing staff, either for economic or other reasons, to engage in procedures which those staff, simply for reasons of conscience, cannot do. Reasonable accommodation, my lords, of conscientious objection is a matter of liberty and equality, of individual freedom and social inclusion, and that is why I believe this is important and timely legislation. I have heard that there is widespread support for this bill. I know it has attracted support from all sides of this House and from the Commons, and I hope that in moving it through second reading, we will enhance the quality of the service provided to all our people and the environment within which healthcare professionals work. My Lords, I beg to move.